finish our discussion on problem areas in jurisdiction, let's cover the matter of addressing lack of jurisdiction. I'd like to remind everybody of the basic rule that absent jurisdiction, the only thing a court can do as provided by the rules is to dismiss the action. In our readings, I called attention to the case of Gonzales. In the case of Gonzales, it was held that the matter of whether the RTC resolves an issue in the exercise of its general jurisdiction or of its limited jurisdiction as a special court is only a matter of procedure and has nothing to do with the question of jurisdiction. To get a better understanding of the ruling in the Gonzales case, let's talk about the situation prior to the ruling in the Gonzales case. In the Gonzales case, it had something to do with an intra-corporate dispute. And prior to that case, if an intra-corporate dispute is brought and filed before an RTC, which is not sitting as a commercial court, the RTC that is not sitting as a commercial court must dismiss the action, pursuant to the general rule that if the court does not have jurisdiction, the only thing it can do is to dismiss the action. In the same manner, if an ordinary civil action, meaning not an intra-corporate dispute, is filed with the regional trial court sitting as a special commercial court, then that special commercial court, that RTC sitting as a special commercial court, should dismiss because it had no jurisdiction. So, the basis of that rule was that an RTC designated or sitting as a special commercial court is an RTC with limited jurisdiction insofar as those cases are concerned. Your regular RTCs, so to speak, or those RTCs that are not designated as special courts, have what is called general jurisdiction. So prior to the ruling in the case of Gonzales, there was a distinction between an RTC exercising general jurisdiction and an RTC exercising limited jurisdiction. The ruling in the Gonzales case is significant because it has taken away the distinction. And what do I mean when I say it has taken away the distinction? That means now that if one mistakenly files an intra-corporate case with an RTC that is not sitting as a special commercial court, that RTC no longer or can no longer dismiss the action. That RTC simply refers back the case to the clerk of court, and the clerk of court refers it to the special commercial court. In the same manner, if a case is mistakenly filed before the RTC sitting as a special commercial court, that RTC now would not have the power to dismiss it. Rather, it will do the same thing. It will endorse the case back to the clerk of court, and the clerk of court will re-raffle it among all the other branches of the RTC, assuming that it is a multi-sala court. That's the significance of the ruling in Gonzales. So the matter of the RTC exercising general jurisdiction or limited jurisdiction, that distinction has been taken away. And this ruling in Gonzales was rendered by the Supreme Court en banc. Moving on. If a court acts without jurisdiction, I also remind you again of the basic rule. If it has no jurisdiction, then all acts undertaken by it are null and void. If it eventually renders a decision, the decision is likewise null and void. If the decision is null and void, then it cannot be the subject of execution. So we have our basic rules. Dismiss if it is without jurisdiction. And acts undertaken are null and void. So once we have been able to determine that a court does not have jurisdiction, we now go to when can we question the absence of jurisdiction. The absence of jurisdiction can be questioned at any stage of the proceedings, even if the action is already on appeal. So that remains to be the rule to date. You can question the absence or the lack of jurisdiction at any stage of the proceedings, even on appeal. Notwithstanding, we need to have a discussion of the case of Tiham. In Tiham, it centered mostly on the matter of laches. And what is laches? Laches, as stated in the discussion outline, is the failure or neglect for an unreasonable and unexplained length of time to do that which by exercising due diligence could or should have been done earlier. It is also described as negligence or omission to assert a right within a reasonable time that would now warrant a presumption that the party entitled to assert it has either abandoned or declined to assert it. That is laches. In the case of Tiham, this was a situation where a party was supposed to have asserted lack of jurisdiction, but actually waited until a decision was rendered by the court, and when he was unable to obtain the relief that was desired or expected, that was the time that a question on jurisdiction was raised. So the Supreme Court, in ruling on that situation, utilized laches as a means of preventing the party questioning jurisdiction from being able to overturn a decision rendered in favor of the adverse party. So that's the doctrine of laches. Now, when can there be laches? There can be laches if one does not take action despite having the opportunity to take action. Meaning, action should be taken, but instead of taking action, the party supposed to take action allows the situation to continue, allows it to develop. Therefore, there would now be a lapse of a period of time from the time or from the period he should have taken action, and that lapse of a period of time will now be taken against him. So there would be estoppel, what is known as estoppel by laches. So in the case of Tiham, what happened? The judgment was allowed to stand. Now, a question now arises whether that judgment was rendered by the court with jurisdiction. Well, in that particular situation, that judgment was allowed to stand and parties were to be governed by it. not because the court that rendered the judgment had jurisdiction, but rather because it was imposed by the court as a sanction for the inaction of the party who should have raised the question of jurisdiction at the earliest available opportunity. In the subsequent case of Kalimlim, which I called attention to, it qualified the ruling in Tiham, where it said that it applies only to exceptional circumstances and there can be no estoppel if there is no laches. That simply means that we are going back to the general rule that the absence of jurisdiction may be questioned at any stage of the proceedings, even on appeal. So, if a period of time has already lapsed or certain proceedings have already been undertaken, and it is only at that time that the absence of jurisdiction is discovered or realized, can you still raise the issue of jurisdiction? Yes. Will laches apply? No. Why? Because it was only at that time that the absence or lack of jurisdiction was realized or determined. Laches will only come in if there is a point in time much earlier where the absence or lack of jurisdiction was already known to the party who is now being, or to whom laches will apply to. He was aware that there was really a ground to question lack of or absence of jurisdiction, but did not do anything. Then that's the time that laches may set in, and eventually he may be stopped from questioning the lack of or absence of jurisdiction. With that in mind, we now go to a distinction between subject matter jurisdiction and jurisdiction over the defendant. This distinction has to be made insofar as this present discussion, because the rule is jurisdiction over the subject matter is a matter of law and cannot be conferred by consent or agreement of the parties. On the other hand, jurisdiction over the defendant can be conferred by a waiver. Simply put, there can be no waiver of subject matter jurisdiction. This is what you can question at any stage of the proceedings, even on appeal. Applying the ruling in the case of Tiham and eventually Kalimlim, we add another qualification. While it is true that you can question the lack of or absence of jurisdiction at any time, even on appeal, you must not, however, be barred by laches or estoppel. So are we clear? So I will repeat. The general rule is jurisdiction can be questioned at any time, even on appeal. We have to be concerned and be aware of the rulings in the case of Tiham and the ruling in the case of Kalimlim, because they deal with laches. So, how does it qualify the general rule? It qualifies the general rule in the sense that, yes, you can question jurisdiction at any time, even on appeal, but you must not be guilty of laches. Because if you are guilty of laches, then the rulings in the case of Tiham and eventually Kalimlim will be applicable. But I remind you, in the case of Kalimlim, it qualified Tiham by saying that it will apply only in exceptional circumstances. In other words, where there is a clear indication of laches and inaction, when there is really a requirement that one must have acted on the lack of or absence of jurisdiction at that particular time but did not do so. On the other hand, lack of jurisdiction over the person of the defendant is something that can be waived. So when we speak of lack of jurisdiction, we are talking specifically, or we are more concerned rather, that's the correct term, with lack of subject matter jurisdiction. This has changed dramatically because prior to the amendments that became effective in May 1 of 2020, when there is lack of jurisdiction over the person of the defendant, that lack of jurisdiction can be questioned and it may eventually lead to a dismissal. But when we discussed Rule 14, we had mentioned, or I had mentioned, that when a motion is filed before the court precisely to question lack of jurisdiction over the person of the defendant, what happens is counsel is designated as a sheriff or a special sheriff for purposes of serving summons upon his client. So the rules now as amended have figured out a way to address or to somehow eliminate or minimize any question as to lack of jurisdiction over the person of the defendant. We now go to your remedies. And what are your available remedies? So the first remedy that is available and which one should take advantage of or utilize at the earliest opportunity is a motion to dismiss. A motion to dismiss remains to be an allowable motion despite the amendments. This is one, or lack of jurisdiction is one of the grounds that may still be utilized for a motion to dismiss. So if a motion to dismiss has been filed, the two things that can happen would be it is going to be granted or it is going to be denied. Speaking of a motion to dismiss that is granted, we have to make this distinction. If you're talking of a motion to dismiss on the ground of lack of subject matter jurisdiction, then the action is dismissed and the remedy of the plaintiff is to refile in the proper court. But if you are filing a motion to dismiss on the ground of lack or absence of jurisdiction because the defendant has not been served with summons in a proper manner, the motion to dismiss is not really going to be granted. Or if granted, what will happen is there will be service of summons by counsel. The other thing that can happen to the motion to dismiss is that it is denied. If a motion to dismiss is denied, your next remedy is to file a motion for reconsideration. If the court maintains the dismissal or the denial of the motion to dismiss, then your remedy before judgment is to do a Rule 65, petition for certiorari. Because a petition for certiorari is grounded on the lack of or absence of jurisdiction, or abuse of discretion or excess of jurisdiction amounting to a lack of or an excess of jurisdiction. But after judgment, the remedy now is appeal. It can no longer be a Rule 65 petition for certiorari because there is some other plain or adequate or speedy remedy, and that is appeal. Excuse me. And if appeal is the remedy, then the lack of or absence of jurisdiction is going to be an assigned error. On the other hand, if the judgment is final, then the remedy would have to be annulment of judgment under Rule 47. The case of dynamic sign maker is instructive because not only does it speak of what can be done insofar as a judgment rendered by the court that lacked jurisdiction, it also makes mention of the validity of the judgment. It said, the validity of a judgment or order of a court or quasi-judicial tribunal which has become final and executory may be attacked when the records show that it lacked jurisdiction to render the judgment. A void judgment, so it calls it a void judgment, may be assailed or impugned at any time, either directly or collaterally by means of a petition filed in the same or separate case, or by resisting such judgment in any action or proceeding where it is invoked. It even went further to say that the testimony rendered in the proceedings that had been nullified for lack of jurisdiction is inadmissible as evidence. So the remedy here is annulment. Annulment on the ground of lack of jurisdiction. When can this remedy be availed of? It can be availed of at any time before it is barred by laches or estoppel. The case of dynamic sign maker also makes mention of a collateral attack. And what is the meaning of a collateral attack? A collateral attack on a void judgment is one that will allow a party supposedly affected by it to raise it in some other proceeding. Like, for example, when the judgment is supposed to be executed, the defendant can file a motion to quash the writ of execution. On what ground? On the ground that the judgment sought to be executed was rendered by the court without jurisdiction. That is an example of a collateral attack on a judgment that has been rendered by the court without jurisdiction, which, as described in the case of dynamic sign maker, is a void judgment. So these are your remedies insofar as addressing the lack of or the absence of jurisdiction. So to summarize, your first remedy upon realizing that the court does not have jurisdiction is to file a motion to dismiss. That motion to dismiss may be granted or it may be denied. If the motion to dismiss is denied, your next remedy is to file a motion for reconsideration. If the motion for reconsideration is likewise denied, then your next remedy would either be a petition for certiorari under Rule 65 if there is still no judgment, or if a judgment has subsequently been rendered already, your remedy is appeal, assigning as an error the lack of or absence of jurisdiction. If, on the other hand, the decision rendered by the court without jurisdiction has become final, then your remedy or your remaining remedy is to file a petition for annulment of judgment under Rule 47, alleging lack of jurisdiction at any time before it is barred by laches or estoppel. Or, if you do not do anything, you may collaterally attack that judgment rendered by the court without jurisdiction in any proceeding where it is sought to be enforced or invoked against you. Like in our example, there is now execution. You can invoke the nullity of the judgment to resist execution. That is a collateral attack on the judgment. So with that, we are done with our discussion as to jurisdiction. For purposes of our next discussion and next topic, I'd like you to begin reading Rule 2 and Rule 3. If there is need, I will call your attention or assign specific readings in addition to the provisions of Rule 2 and Rule 3.